morning. I'm Heledd Wyn, Rothley Law, and today I am delighted to be joined by Josh Hayward, who is a trainee solicitor and I think this is really interesting. Wills, trusts, probate, non-contentious, and contentious trusts and probate, which I think makes you a bit of a unicorn, Josh.
Thank you.
And as anybody who knows me knows that I say I'm at the shouty end of private client. So it's really interesting to find somebody who's coming through on the journey who's perhaps looking at both sides. So Josh, tell me a bit about yourself, how you got into where you are.
Um, well, it's interesting. I mean, getting into law was really the first thing. I mean, I suppose I'd always had an interest in law. One of my grandfathers, he used to be a police officer, so I think that's what sparked the interest. But then when I discovered I wasn't one for the physicalities of that job, I started to look elsewhere. And I think that's where my interest in law really started. Um, which led to me doing law at university twice. But I never really found an area. Um, After university, I always wanted to do employment law, and that was where I sort of wanted to go. Sort of fell into private client, as I think quite a few people do. I don't think it's ever sold as one of the most glamorous areas of law. And I think when you do trusts at university, the it's never the class that people look forward to, really. Um, Certainly wasn't one that I looked forward to at the time. But after university, I sort of fell into it and actually discovered I quite enjoyed it. I first started just doing purely probate, um, but then I got to a point where where I learned a bit about the post-death stuff, but I wanted to do a bit more of the pre-death stuff as well, which led me to the firm I'm at now, which does a full host of private client work.
I think what you just said resonated. I fell into private client. You fell into
Yeah,
private client. And I think it's
yeah.
exactly that. I think it's like, it's not that sort of, oh, come and do commercial contracts, come and do
Hmm.
litigation. And, trusts in university is a bit mysterious.
It is.
Even all these years later, I think, it makes sense now. But,
Yeah.
the concept of trust when I was doing it, academically, I was like, I'm really not sure what this is.
No, yeah, it's one of those that you're not really sure where it fits, and you learn the different rules, but you think, well, how does this actually work in practice?
Yeah.
And it's not until you actually work with trust you actually understand how those rules work.
Completely. Now you say you did law twice. How did you end up doing law
Yes.
twice?
Well, I did law at undergraduate, then I did a postgraduate as well.
Ah, you go see glutton for punishment.
Yes, sort of. I suppose the postgraduate was was the bar course as a master's.
Okay.
Um, so I did that back in 2020 now, so over the COVID year as it was then. Um,
Oh.
and afterwards, I sort of discovered the bar. Well, d during it actually, I discovered the bar wasn't for me. Um, Not because it, I it was an interesting one because I think over COVID there was a whole self-employed thing, which sort of um, affected my view on it. I mean, there's plenty of barristers who did well out of that, and as uh, it's still going now, but certainly put doubt in my mind. And also the fact I wasn't sure how much alcohol was involved at the bar.
They're a mysterious law, our sort of
They are
barrister brethren. Lovely, you're all lovely, by the way.
absolutely, yeah,
Okay, oh, that's interesting. And so you've come to the come to the dark side, over to the solicitors,
yeah.
and you're doing your SQE. Not only are you in this really interesting um space, which we'll talk about a bit more, but
Hmm.
you're also doing your training alongside it.
Yes. Uh, Still coping well. Not had a breakdown yet. I mean, it's I think anyone who's worked full time and studied alongside that can absolutely relate to how difficult it is. I mean, there's certainly people I work with now who've done exactly the same, and it is difficult. I think with the SQE course, the way that it's structured, it's probably made it a bit harder for people. I'm not saying the LPC was easy by any standard, but because of how intense the SQE is, I think it's made it a lot more difficult for people to perhaps manage, really.
Oh, well, hats off to you. I mean,
Thank you.
I'm seasoned enough, I think is the right word, to say, I did the LP, I did very traditional route. I did,
Mm,
A levels, law degree, LPC, short since paralegal
yeah,
training contract. Although I noticed from your LinkedIn profile, you went to school in Prestatyn.
I did.
Uh,
I did.
so
Grew up in
we're from
Wales.
Wales, so a very, very similar part of the world, and you will know where I did my training, which is Gamlins. Um,
Yes, I know Gamlin. Yeah.
yes, so I'm just thinking about being thrown in the deep end, and I
Mm,
started doing probate. I don't know whether a lot of sort of private client solicitors get thrown into probate as the thing to cut your teeth on because you see
mm,
it beginning to end, don't you?
yeah.
What would you say your experience has been of, as you say, starting in probate and then,
I I think out of all the areas of private client, probate is probably my favourite because it is one of those where it's a long process, and it's probably the best place to build a client relationship because there's I mean, if you're just doing a normal estate administration, there's not going to be anything contentious. You're going to be working with them for at least 6 months, if not longer. Definitely longer nowadays with the probate registry. Um, so and you do see it from from beginning to end, and by the end, you know that estate inside and out. Um, but I think why it's still my favorite is it's where I started. Um, I mean, I started on very simple estates, and now I have really complicated estates, which again I enjoy. I like the complicated stuff. I don't run away from it, which I think a lot of people look at me weirdly for. Um,
oh, we like being a weirdo. Nothing wrong
exactly,
with that.
yes, yeah. I think with most of my estates, there's some sort of complexity to them, which I enjoy. And it certainly makes the job interesting and makes training interesting as well. Um, so yeah, I think with probate it's what I know. Well, I know a lot of different things actually, not just probate, but it's um, probably where I feel most comfortable, really.
I think it is interesting because I think you get to see people, don't you?
Mm,
You get to know if it's you either sort of meet your sort of client because you've known them,
hmm.
and then they've died, and then you take it forward, or the first thing you know is meeting the family.
Yeah,
And I think it's a fascinating area when you get to know what somebody's about, and you can tell a lot from the way your will is written, can't you?
absolutely. Yeah,
Um, Family dynamics and family behavior,
yeah,
and what sort of so that moment of expectation when you open a will envelope and go, right, let's look what this says.
yeah. And
Oh, we're gonna
or or you open the will file and you find a statement of non-provision. You think, oh, here we go.
oh, here we go. Yes, more than one occasion, had that
Yes.
sort of thought and conversation, and I think for me it's that sort of understanding the bigger picture because
Hmm.
probate probate's part of the process. The
Yeah,
estate administration is the bigger piece, and I think the family dynamic management for me is a huge part. I don't know how
absolutely.
you feel with that, or which aspect you like most.
I think with me, it's very much the technicality side. I mean, I say this, but I love an IHT 400. I love filling them in. I love submitting them. I think it's because as as long as the forms can be, you're seeing everything in one place, and it's equally as clear. Um, and it's a way of accounting to the executors that, look, I've investigated everything. I've everything's been reported that needs to be reported. Is there anything else that you've not told me about? Um, and, and going from there, and it is often the case that an executive will want to come in and actually say, well, can we go through the forms with you because you've sent us t 10 different forms. We don't actually know what we're looking at, which, granted, most people who look at an IHG 400 panic, particularly if you've never done one before anyway. Certainly I did on my first one. I thought, what on earth am I doing with this?
You're absolutely right, because it's a form, and the government is very clear. You can
Hmm.
download everything, and it says you can fill in this in yourself, and yes, you can. Now, whether you can fill it in correctly and accurately is a whole different conversation. I remember talking to somebody once, and they said that there is a psychology to form creation.
Yeah.
The forms, a well-written form is a good thing. A badly written
Hmm.
form is an absolute horror to do. And
Yeah.
I think what's IHD 400 is hundreds of pages if you're going for the full suite.
Absolutely.
And
Yeah.
you've got to really sort of understand all those intricacies and all those interlinking pieces, don't you? And it's
Hmm.
not just, well, we've got this much money and, there was a funeral. There's always something else
Yeah.
to do, isn't there? And yes, I had a colleague as well who said who also loved estate accounts. So because they're a beautiful thing, and you'd
They
come
are.
and you'd go,
I
a
love an
lovely
estate
thing.
account.
I get them to balance.
They're lovely when they balance, yes. When they don't balance, they are a nightmare.
So, um, so talk to me then about the contentious side. Why both? How both? How are you balancing it?
Balancing it well. I think my interest with the contentious side probably derived from when I did the bar course. I'd always been interested in the litigation side, um, probably because I was always told I was good at arguing, at school. Um, so I think that's probably where it started, and having the opportunity to do an area which I enjoy, which is the non-contentious side, but also being able to do the contentious side seemed to sort of make sense to me. Um, it sort of developed from that. I mean, when I started in contention, I knew basically nothing. Um, I knew what the Inheritance Act was, and I knew what a will of validity dispute was, but I didn't actually know the mechanics of how they worked, how they progressed, um, and now I do. Which I think if I'm meeting with an executor to do for an estate administration, and they say, "Oh, actually, there's an estranged son who's already said he's going to make a claim," you think, "Okay, fine, let's let's apply for probate as soon as possible to get that 6 months started and end, and then at that point we'll know whether he's made a claim or not." Um, so I think it's added the benefit in that instance, and I think to balance, and it's very much the case that I'll see people who they come in about one thing, but actually there's another contentious issue. So if I can deal with both elements in one meeting, it saves them time and saves another person coming over from another office, just to have an hour meeting with them to go through stuff. So actually, I think it makes more sense for some people to do both. I'm not saying everyone should do both because not everyone will want to do both. Or I think nearly everyone in our non-contentious team here say, I never want to touch contentious probate, um, which I think there's a lot of non-contentious private client lawyers out there who will agree. Um, but there are those like you and I who actually quite enjoy doing both.
Absolutely, and I think that um I enjoy seeing that sort of bigger picture stuff. So I think if you can understand the Inheritance Act claims, and you can understand the
Hmm.
proprietary estoppel, and you can understand
Yeah.
the undue influence, you can flip it around and go, okay, well, we know what it looks like when it goes wrong. How do we prevent it if we can, and we
Absolutely.
can then I think we can then better stress test it
Hmm.
to go, okay, this client is adamant they want to do this thing, and I know full well this is going to cause mayhem.
Yeah.
How do we marry the two things up
Hmm.
in a way that client gets what they want, we don't get sucked into negligence or
hmm
problematic files, and allow people to have that testamentary freedom to do things that are capricious and
Yeah.
difficult and odd, and go, okay, well, we've for me, I've knocked off all the sort of usual suspects. Yes, you've got capacity. Yes, you know full
hmm
well you're cutting out this child. This person you don't think has any claim on your estate from what you've told me.
hmm
Um, we know there's nobody else in the room or even around. You're just doing
No.
this because you have that sort of personality and relationship with this family dynamic. And okay, well, this is possibly not going to go well, and you're going to upset people, but you are within your rights to do so.
hmm
And I find that endlessly fascinating. I think people are endlessly fascinating, aren't they?
Yeah. And it's often the motivations why they want to do something. I mean, in some cases, we're doing a statement of non-provision because they were divorced from someone 20 years ago and they can't remember whether there was any provision made in the financial order.
Mm-hmm.
Fine. That's nice and straightforward. But in other instances, it's the case that, oh, my son and daughter have not spoken to me in X, Y, and Z years. The last time I saw them, they called me a liar and blah, 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 blah. And it changes what you're putting in that statement of non-provision. And it probably changes and it's more important to consider what they're actually doing because in some cases it's, oh, I had a falling out with my son last week. He's never speaking to me again. I want to change my will. Okay, it was a week ago.
It was a week ago.
You've not spoken for a week. Are you sure you want to do that? Because by this time next week, you could have made up again and you'll see me again to say, let's put it back in. So actually, are you doing the right thing? But then, as I said, in other cases, we've not spoken in 20 years. We have no we have no relationships. I don't maintain them. You think, okay, in which case, that's more reasonable. Or not more reasonable, but it makes sense as to why they're doing it.
Completely. And yes, those regular fallouts and
hmm
those people who change their wills every 5 minutes,
Yep.
because it's something to do, isn't it?
Yeah. It's a hobby.
Yeah. Okay, well that's fine. We can accommodate, but obviously it's building up that picture, isn't it? Of going, no, this is what this person was like.
Yeah,
And I always think, we can reduce risk. We
absolutely.
can't remove risk.
hmm
And I think in a private client, um, it tends to people want everything to be perfect and tied up in a bow,
Yeah.
and it's not, because you can make your wills beautiful and you can make your powers of attorney, your trusts
hmm
beautiful, but you can't make your clients' lives beautiful, because if
No.
they've got difficult lives, and I always say I can probably count on the fingers of one hand the number of clients I've had where they've had a sensible, not problematic dynamic somewhere in the family.
hmm
Because from the sort of estate planning side, and you'll no doubt see the same sort of thing, is that it's like a confessional. People come in and
Yeah.
tell us everything. And I often think, God, bet Christmas around your house is fun.
It's that, and you've always got to think, okay, how do I react professionally to that?
Yeah. And you go, okay, well, this is interesting.
Yeah.
You swiftly learn the sympathetic head tilt. Hmm.
Yeah. I often go there, okay,
Yeah.
interesting.
Interesting. Exactly. I mean, the poker face requirement is
Yeah.
actually quite high. And it's real, isn't it? These slights, whether real or perceived,
hmm
hurt, don't they? And you can see it in family dynamics, and you can sit
Yeah.
there. You go, they come in and they go, okay, when you're going through your sort of who have you got, who should you be giving consideration to? Do you want to keep it in the bloodline? Do you want it to go to spouses?
hmm
Children, grandchildren? And it doesn't take very long before somebody goes, oh no, not that person.
Yeah. It's quick. I mean, I was actually having a conversation with someone recently, and they will have been drafted by someone else, but they provided for I think their son's children. Um, but that son doesn't hasn't spoken to his children in years, and you think, okay, you might want to go back and get them to amend that, because as it happens, that's going to that's what will happen if your son doesn't survive you, and it's not what you want, and it's not, I'm sure, not what he would want either.
Yeah,
So really, it's always interesting how family dynamics work. And I think as private client lawyers, we see that quite well. And as you said, it's very much a confessional, because they can tell you the interesting intricacies of how their family works,
yeah,
and some of them are incredibly interesting.
incredibly, endlessly interesting.
Absolutely,
It's the best bit talking to clients.
it is.
And of course, client confidentiality means we don't. And I think, unlike our sort of maybe our litigation brethren,
Mm,
who get reported cases,
yeah,
who go, look, this is what I did. Every time we do anything, it's like, mm, it's very interesting,
yeah,
but I can't talk about it.
yeah. It's really interesting, but sadly,
Yeah,
I've got to keep stum.
got to keep stum. And yeah, so have you had to do much advocacy, or have you been encouraged to do advocacy with your bar background, or you sort of have you managed to escape the worst of it?
No, I haven't, and I don't really want to do that. Um, I think advocacy is always something that I enjoyed it when I did it, and okay, I would like to do it, but I think probably in trust and estate litigation, it's probably better left to a barrister who does it professionally. I think I don't know why I have that view. It's just a view I have. I mean, in family in family proceedings, it's very common to have a solicitor who will advocate on your behalf. Um, but I do often wonder whether that would translate equally as well into trust and estate litigation, because I do think it's a different kettle of fish from when you are meeting with a client, advising them as a solicitor, to advocating on their behalf in front of a judge in court as either solicitor advocate or as a barrister. I think there's quite a big distinction between the two. Um, so, I mean, if I was ever forced to do it, I give it a whirl, but it's not necessarily something I'm setting out to do particularly.
And I think you're right there. I think sort of using barristers
Yeah.
can be really useful because it's different training, it's different skill
Hmm.
sets, and actually you can then bounce ideas off.
Absolutely.
And I find that really useful, is going, okay, well, I think I've got so far with this as I'm sort of crafting my instructions to counsel, and this is what I think the option is. And then you put it in front of them, and you have a conference, and they go, nah, have you thought about this? No, that's what you're here for. Thank you.
Yeah,
And I think that's incredibly helpful. So I think it is sometimes a second pair of eyes
absolutely.
on it.
Yeah.
Um,
It was like a recent one, I thought it was a weak claim. The partner who I work with, he thought it was a strong claim, sent it to council, and council said, no, it's quite a weak claim. So two of us in the same firm had different opinions. So we needed that third opinion really to break the tie. And I think having that does help because, as you said, it's a fresh pair of eyes.
completely. And I always think that I always come back to this idea that somebody said to me, in litigation, 51% is good enough.
Yeah,
No, it really is just on the cusp of being good enough. But
I'd like that to be a bit higher.
I'd like it to be a bit higher. But it's that if you're playing the odds
Mm,
and you go, well, we're starting, if it's at least 51%, we're at least starting on that journey. You're going, we're in the right.
absolutely.
So yeah,
Uh,
I mean, I'd obviously like 80% plus, but
we can't have everything, but I think when it comes to having barristers, because they get instruction from a variety of from a variety of solicitors, they probably see more. I mean, there's always those weird and wonderful applications, and you think, oh, actually, what do I need to put into this? Whereas, if we've never done that sort of application before, but council has, then surely it makes sense for council to draft that application because there's no point us drafting it, send it to him because he might end up rewriting the whole thing.
Completely.
So really, if they've got more experience in the weird and wonderful, let them do as I say.
I think quite
That's what
right.
they're there for.
Exactly. They've done their training. I've done mine. It's fine.
Yeah, yeah,
We are the stronger together. I'm a firm
absolutely.
believer in that. So have you had much sort of, have you had any trials yet? So we appreciate sort of early doors
Mm.
in your career, but have you had to sort of, get to that stage, witness statements, being called as a witness, going to trial?
Not yet. We've had one where it went to an early neutral evaluation, back in, can't remember when it was now. Uh, and I mean, that was more or less half a day. But I think that was the best day I've had in work in ages, because I just got such a kick out of going to court. It was actually it was really quite exciting. I felt a bit like a kid in a sweet shop, to be honest. Um, because I think it's a different environment. Um, okay, you know what you're doing, and you know what's being discussed, but actually when you're taken out of your normal environment with what you know to put in a different one with what you know, I think there's an added excitement to that, really.
I think there is, and I think personally, and and it is personal preference, isn't it? In sort of what practice area you end up in, and because
Hmm.
I do traditional private client, wills, tax, trusts, probate, I do care fee planning, and I do contentious court protection and other
Hmm.
court protection applications, which makes me slightly unusual in the sort of pantheon of private client lawyers, but that's okay because but I think for me it's that point of getting a different perspective.
Yeah.
That sort of going, well, actually, some you if it's contentious, it's okay. You're challenging somebody else's will. You're challenging because all you see is the will, and then you have
Hmm.
to look behind the will, and then you have to look at the ideas why the will was drafted in the way it was drafted.
Yeah.
And I think that makes me a better lawyer when I'm doing the estate planning because I can sit there and go, look, from experience, I
Hmm.
can see this. And I posted it the other day on LinkedIn. Um, I've done one will reading in my life. Never again.
No, absolutely. I was speaking about will readings with one of the partners in our team, and she was asked to do one once, and she had her previous paralegal there as a witness, just because she knew it was going to be contentious. So she thought, I'm not doing it again. And I, I've never done one. I don't particularly want to do one, because I think they can cause such issues and arguments in that room. And actually, that's not the purpose of what a will reading is. It is there to read the will, they go away, and they can fight it out between themselves.
Yeah. I swear, I swear on my mother's life, I'm never doing another one
Yeah,
ever.
no,
I'm like, I don't care how much you want it.
yeah, and it's always interesting when they ring up and say, "Oh, we'd like a will reading, please." And you think, well, that's not how it works. Actually, we need to meet with the executors first.
Yes, it's not
And I think,
some sort of American movie or some sort of Victorian melodrama.
no,
Or it'll quickly become one. I can tell
yeah,
you that. I can tell you that from experience. But yeah, it's. I always say it's grief and money.
hmm,
And that works both ways. I think grief or anticipatory grief of not being here and what do you want your legacy to be can be very hard for some people.
yeah,
And that grief of a lost loved one, um, and then how that money is distributed
mm.
it is quite interesting. And I do have some clients who are delightful, uh,
So do I.
but they're not the interesting ones.
No, no,
They're not.
they're the
They're
nice and
not the
easy
war story.
ones.
Yeah, they're
No,
not the war stories, are they?
no, no. But I think as private client lawyers, when we see a will that's written 15 years ago, and it doesn't make, it doesn't fit what the circumstances are now, we tend to have panic attacks and we think, okay, we can see a lot of issues here. Um, we know it, it it's often the case that what the will says isn't actually what the person wants, and you think, okay, where do we go from here? And it's that challenge of thinking of a solution that pleases everyone. And in a lot of cases, you can't please everyone. I,
You
I,
can't.
I I think we both know that. Um, but it's often the case you've got to think, okay, what's the best solution, but actually, what's also the most helpful solution?
And I think you've hit on something there. I think the word solution.
Mm,
I think that's crucial.
yeah,
I think we are here to be problem solvers. And I remember when I was a trainee, so same boat as you, some time ago.
not
My
that long
boss,
ago, I'm sure.
oh, you can come again. Um, my training partner sat down and he went, "You're not here to be a cipher. You're here to
Hmm.
be a lawyer. You're here to tell people what the law is, apply the law, advise them, not just let them tell you what to do and then go with it." And I was like, makes complete sense now you said it like that. And and I've always taken that with me. And I go, well, hang on, there's a temptation to go, I want to please people, and
Hmm.
I don't like conflict. And I think again, sort of, being in a slightly shoutier, for want of a better way, private client sphere, I think
Yeah.
I am less interested in pleasing people
Mm,
than going, sorry, you might want that, but if that's how you want to go, I'm not the person for you,
yeah.
because I'm not willing to put that in writing, or I'm not willing to say that. Um, and that's fine.
Yeah.
That's absolutely fine. If
Absolutely.
like in litigation, you've got some absolute um, incredibly sort of aggressive litigators. And I was talking to my
Hmm.
litigation friends and colleagues recently, and we were talking about the 5 p.m. email on a Friday. It's
The
like
worst one.
there is no need to ruin anybody's weekend with that. Just let it go. Delay it
Yeah.
till Monday. You're not going to get anything done over Friday, but you're just going to go, do you know what?
You're going to upset
Yes.
someone's weekend.
Well, the litigation can wait till Monday. And other times you've got people who are supremely sort of never seen the light of a courtroom,
Mm,
and are incredibly technical. And there is space for both.
yeah.
There's always a bell curve. Um, I'd like to think, we or a pendulum maybe rather than
Yeah.
a bell curve. I think there's space for everybody, and it's where do you sit in that space in the middle.
Hmm.
And I think that you know I think it's really interesting to hear you going down the route of actually having the dual discipline. So
Hmm.
so do you if you to your fellow trainees and the SQE people,
Yeah.
how are you balancing effectively two jobs and the SQE?
Um, well, I've started getting grey hairs at 25, so that sums everything up. Um, I think there's always going to be that challenge because with litigation, you've got timescales you've got to stick to, but also you've got the timescales with non-contentious stuff. Are we getting the wills out in time? Are we getting the powers of attorney out in time? You know, what about these estate administrations? What's happening on these? So there's a lot of different competing demands. Um, I think doing both different disciplines, it's trying to manage both of them. I don't know how well I'm doing that. You'll have to ask my supervisors how I'm managing that. Um, I've not been told off, so I'm assuming it's quite good.
Oh,
Um, but
usually a good sign.
yes, yes. Um, but then all of the other trainees who uh, are in our firm, they tend to do one or the other. So if they just do they just do conveyancing, they just do conveyancing, that's it. They might do a bit with the contentious team, but not a huge amount, just to have that sort of exposure. So it's not as if we had one trainee who was in residential conveyancing, she worked with a trainee in our family team, but it wasn't the case she was running family files or doing divorces or child proceedings. She was there shadowing really. Um, whereas me, I don't have the luxury of shadowing. I am thrown into it. But I still think that there are benefits to that. I mean, I think as a trainee, there are particularly benefits to that. The partner in our litigation team who I work with, he's not a private client lawyer. I'm sure, hope he won't mind me saying that. Um, and it's often the case that he'll ask for my opinion on stuff, on either contentious probate stuff, capacity issues, and actually as a trainee, quite rewarding to be asked a question by a partner for what your views are. I think, it's often the view that, oh, I'm a trainee, I don't know anything. Um, they're a partner, they know everything, um, which isn't always the case. And uh, you know, and being asked my opinion on stuff is actually quite nice to have, and quite rewarding, I think.
Trainee's great because
Yeah,
trainees have done their law degree much more recently than I have.
yeah,
And I always say, I said, look, I've been knocking around longer than you, which means I have more experience than you just by dint of knocking around longer than you. But that doesn't mean I'm more important than you, or,
no,
actually you might have read something recently that has passed me by because, there's so much to take in all day. So
hmm
it has to be a two-way process. And having somebody who can work, like that is fantastic. So, well done to your supervisor, I would say.
yeah, yeah, and yeah, I think as a trainee, there's more opportunity for you to learn more, whether that's learning from someone else or going away, researching stuff, and then later applying that, which I actually did quite recently. I did a blog post about 2 years ago about life interest trusts and rights of occupation. 'Cause I think at that point there was a case that came out that said, um, it was essentially that if there's a life interest trust, but tax can't be paid, HMRC can end that trust. I didn't know that before. Um, but then I had a client about a year later who there was a life interest trust, but they couldn't pay the tax. I was like, well, this is what the position is. I remember this.
Perfect.
Whereas if I hadn't have had that time to go away, I didn't read the whole case, I will say, because no one has that time. Um, but reading the commentary and a summary of the judgment, you think, oh, actually, um, if I hadn't have had that time, I wouldn't have known that.
And I think it is that luxury time,
Hmm
um, that we know, as you say, partners and trainees and everybody in between, and
hmm
everybody's got to start somewhere. And every
Absolutely,
day's a school day. Doesn't matter. I don't care. I'm still learning stuff every day. Um,
absolutely.
but actually, you've got that time, and we factor in. You should have time
Hmm
to go and learn stuff. And if you've got time to go and learn stuff, you've got time to go and learn stuff and condense it and give me the bit I need to know.
Yeah.
So that works both ways, doesn't it? Because it's like you've done all the research, it's on you
hmm
because you're trained to be a lawyer,
Yeah.
um, or trained to be whichever branch you're going down. You're going to be qualified at some point, and then it's
hmm
definitely on you. And it's good practice to go.
Yeah.
Actually, no, if I was stood at, if I was had to stand by this, that's what I would say I did, and so show you working. So, it's when you realise your degree is actually quite useful because it takes
hmm
you through takes you through the method.
Absolutely. Yeah.
But yeah, so what do you think that you will still continue to do the two, or do you think you might veer one towards the other, or is that too early doors?
I think that is the plan for me. I think it's the plan that ideally I'd still like to do both, because I think doing both, you get perspective, you use different skill sets, you get different perspectives. I think with non-contentious, you're probably a bit more trusting of people than what you are with contentious. You, with contentious, you think
I like that.
everyone's got an ulterior motive.
Yeah,
Um,
yeah, yeah, that is fair. I think you
yeah,
sort of go, I'm going to dig a
yeah,
bit deeper.
yeah. I think you often you stand back and reflect a bit more with contentious, because you think, okay, well, if this person's having an argument with this person, is someone else going to have an argument too?
Yeah.
Whereas with non-contentious, you think, yeah, everyone gets on fine, they all like one another. That's often the case. Sometimes it's not. But I think you tend to take things more on face value,
Mm.
whilst always having a checklist in your mind of what to do if it's not all flowers and sunshines.
I think that's a really good point. I think on which to end it. I think it isn't all flowers and sunshine either way, either
Hmm.
side of the contentious non-contentious space, because it's, as you say, it's either litigation, which is has its own challenges,
Yep.
or it's trying to manage those expectations that
Hmm.
are going, are potential, always have that potential to blow up.
Yeah, absolutely.
Well, Josh, thank you so much. It's been utterly
Thank you.
fascinating talking to you, and I wish you all the very best in your career. And shall keep fingers crossed. And I never want to see a 5 p.m. email from you.
You never will, because I don't send them at 5 p.m.
Excellent. Well, thank you very much.
Thank you, Heledd.